Welcome back. We're in the middle of a guided tour, so to speak, of the written Constitution, and we're proceeding in textual order. We've already covered the preamble, how we, the people of the United States, ordain and establish the Constitution in an epic act of continental democracy and free speech, the likes of which had never really before been seen in world history, and in an event that really radically changed the course of world history, and that we, the people of the United States, did ordain and establish that Constitution for reasons of national defense, to secure the common defense and thereby preserve and secure the blessings of liberty for that generation of Americans and its posterity. So that was the preamble, and that was the beginning of our guided tour. Then we talked about Article 1, the legislative branch, this kind of new Congress, borrowing the name of the old Congress, but changing its powers and structure quite considerably. The legislative powers vested in Article 1 in this Congress. We talked about the executive power vested in a president, a newfangled president who would be way more than a governor, state governor, but much less dangerous than an English monarch, and that's Article 2 of the Constitution, the executive power vested in a president. And then we talked about, last and I think least among the branches of the federal government, we talked about the judiciary, the judicial power vested in judges by Article 3 of the Constitution. Now, at this point, I hope actually maybe you've noticed two things, or two things have come to your mind. First, the Constitution is actually pretty well organized, sort of preamble, how it's going to be ordained and established, then legislature, executive, judiciary, each in its own separate article, a kind of separation of powers textually, Article 1, Article 2, Article 3. So I hope you notice that the Constitution actually has a rather nice and tidy, cohesive organization. An ordinary farmer 225 years ago could understand the thing, and it is designed to be understood. The Articles of Confederation, the predecessor document, were much more of a jumble, much less well organized, I think. And some of the state constitutions were relatively tidy. Massachusetts Constitution comes to mind. Others were a bit more of a jumble. So one thing you might have noticed is the Constitution is pretty well organized. So I hope the lectures so far have been fairly well organized too, because we're just tracking that textual flow. Now, it's complicated, of course, because you can't really talk about one branch in complete isolation to the others. Let's take the veto power. It's mentioned in Article 1 because it's part of the process by which laws are made, but of course it's a power of the president, and he's front and center in Article 2. Or let's talk about presidential impeachment. Well, it's a limit on presidential power, but the impeachment powers are vested in the legislature, in the House of Representatives, which gets to, in effect, indict a president, charge him, and the Senate, which tries him. And so, too, if a judge is impeached, that's an Article 3 issue because it involves limitations on the judicial power, but it's also an Article 1 issue because the House basically indicts, the Senate tries a thing, and the Senate, when it tries an impeachment, is sitting as a court of sorts. And so that's a kind of judicial power, if you will. So I hope you've noticed it's pretty well organized, but these things kind of fit together, and you can't fully think about one branch of government without thinking about how it checks and balances and interacts with, is blended with, to some extent, other branches of government, even though there's a basic presumptive separation of powers in Article 1, Article 2, Article 3, the three articles, all of which begin with a kind of vesting clause. Legislative power vested generally in a Congress, executive power vested generally in a president, and judicial power vested in courts. So I hope that's one thing you notice. And maybe the second thought that may have come into your mind is like, well, what's left? I mean, we've done how the Constitution is going to be ordained, and we've got the three branches of government, so aren't we done? Not quite. Today we're going to, and in this lecture and in the next one, we're going to talk about Article 4 of the Constitution. And it focuses mainly on relations between the states. Think about a kind of horizontal federalism. Federalism sometimes means the relationship between the state governments and the central government, the federal government. But sometimes it can also refer to, and the things are connected, more horizontal, that first thing is called vertical federalism. The central government kind of above the states to some extent, because when the federal government is acting within its powers, its competence is supreme, the supreme law of the land. We're going to talk about that in more detail in later lectures. That's vertical federalism, the central government kind of above the states. But federalism is also a horizontal concept, the relationship of sister states among themselves. And the vertical and the horizontal are connected. Everything's connected in the Constitution. But Article 4 focuses centrally on the states. We've seen them before. We've glimpsed them before. Of course, powers generally not given to Congress under Article 1 are going to be left to state legislatures. But Article 4 brings states front and center. And not just states, but what about those parts of the United States that aren't states? What about territories, for example? Article 4 is going to focus on that. So it's going to in part tell us how united really are the states horizontally as well as vertical. And it's going to remind us that the United States actually, strictly speaking, encompasses more than states. It, for example, encompasses the national seat, today known as Washington, D.C. That's not a state. It's not represented in the House or the Senate, but it's obviously part of the United States. It's where basically the government of the United States resides. And so too, territories are going to be, and always have been, part of the United States. And Article 4 is going to focus on them front and center. And in this discussion of Article 4, we're going to see really the same great themes that we've been glimpsing throughout our tour. We're going to see the importance of democracy and self-government. Another word for a kind of synonym, really, for democracy at the founding was republicanism. The two were actually very similar, as we're going to talk about in the next lecture. So you're going to see themes of democracy / republicanism, popular sovereignty, popular self-rule. We're going to see the issue of slavery and the companion issue of race emerge yet again, as we've been seeing it throughout. And we saw it even in the question of, like, who is the people? We the people. Well, who counts and who doesn't count? Do free blacks count? Do slaves count? And Article 4 is going to tee that issue up centrally. So democracy, self-government, race and slavery, and the importance of national security and geography and geostrategy will be another thing that we see in Article 4, as we saw that theme in the preamble and in Articles 1, 2, and 3. For example, on geography, recall that the difference between the Supreme Court and the lower federal courts is basically that the lower federal courts are geographically distributed throughout the country, whereas the Supreme Court is going to be in the national capital. And in that difference, actually, you can begin to understand Marbury versus Madison, which says you can't expand the original jurisdiction of the Supreme Court beyond the trial jurisdiction, beyond what the Constitution provides. And one idea is kind of a geographic idea. Certain things are supposed to be tried in the national center, but other things are actually supposed to be tried. They can be heard in lower federal courts, and these lower federal courts are going to be picked, their judges, just like Supreme Court justices, basically, nominated by the President, confirmed by the Senate, but they're going to sit in the hinterlands in the states rather than in the national capital. So these themes of democracy and geography / geostrategy, which we've been seeing, and slavery and race, which we've been seeing in Articles 1, 2, and 3, and in the preamble, are also evident in Article 4. I'm going to come back to this picture, which begins Chapter 7 of America's Constitutional Biography, which is our sort of handbook for this part of the course. Every chapter begins, remember, with a picture, and if you understand the picture, you really understand the deep ideas of the chapter. I'm going to come back to this picture at the end of the next lecture, but just to anticipate a bit, this picture in the beginning of Chapter 7 is from the printer, Benjamin Franklin. It's generally reckoned the first political cartoon maybe ever. Franklin was a very inventive fellow. Bifocals, the Franklin stove, the lightning rod. He could be given credit as having invented the idea of political cartoons, and this is the first one. It's from 1754, way before the American Revolution, and Ben Franklin is urging a kind of union of sorts of the different colonies with the caption, "Join or die." I'm going to come back to this again at the end of the next lecture, but just to remind you of how the United States begins. It begins as a series of British colonies in North America. And originally, these colonies are settled at different times, populated by different demographic groups. Folks from some parts of England end up more in some parts of the New World, and from other parts of the British Empire and Europe, they end up in other colonies. So they're not all kind of homogeneous demographically. They begin as these widely scattered outposts on the Atlantic seaboard, founded at different times for different purposes, sometimes by business ventures seeking to make a quick buck, others by the British monarchy itself, still others by religious dissenters, and others trying to sort of escape the old world and create New World self-government as best they can, while professing allegiance to the crown, but the British crown, but trying to preserve as much freedom and self-government as is possible. Well, as these colonies grow and expand, they start to verge on each other. Borders sometimes get shifted around. But the colonies, you need to understand, are legally distinct from each other. They're connected to the British crown, but not really quite to each other. Imagine a kind of wheel with spokes from each colony to the same king in the center, but not much of a rim connecting the colonies to each other. In 1930, for example, just to flash forward, the British Empire, the British Commonwealth, consists of a whole bunch of different entities that they all have the same common crown, but they're not tightly connected to each other. And you've got Kenya and India and Ireland and Canada and New Zealand and Australia, and they all have a common crown, but not much connection to each other. That's America in, say, the 1750s. And there are British North American colonies to the north in Nova Scotia and Halifax, and to the south in the West Indies. And Ben Franklin, in 1754, thinks there should be kind of more connection among the colonies. He himself is a continentalist. He's born in Massachusetts, and he, at a young age, with kind of pennies in his pocket, just a young man setting out to make his fortune. He leaves Massachusetts, goes to New York briefly, but ends up in Philadelphia, where he does find fame and fortune. But he's imagining, continentalist that he is, way before others are, because most other Americans actually don't leave their home colonies. Most people in the 18th century lived and died in a 50-mile radius, and many of them sort of never ventured beyond that. But Franklin does. He's a continentalist, and as early as the 1750s, he's saying we should create more of a union among the colonies. Still in 1750s under the British umbrella, but there should be more connection actually across these different colonies. He proposes there's a meeting, a gathering, a conclave, a congress, if you will. Among some of the different colonies, they meet in Albany, New York in 1754, and Franklin proposes a plan in which the colonies together will regulate intercolonial affairs. There'll be a council, kind of like NATO or the EU, and they'll regulate interstate affairs, and they will and they will regulate Western territory and handle continental defense, and elect a sort of and the king will pick maybe a presiding officer, a governor of all the United Colonies, and this will all be under the supervision of Parliament and the Crown, but the individual colonial legislatures aren't that interested in ceding power to some central council, and Britain doesn't seem so interested either in bringing all these colonies together, because if you bring them together, who knows what will happen when they start talking to each other. Britain isn't so keen on it. The colonial legislatures aren't so keen on it. So this idea goes nowhere in the 1750s. But see, Franklin, the inventor, he's trying to, as it were, reinvent the wheel. He's trying to create a new kind of wheel that won't just have spokes from the center to the different colonies. He's trying to add a rim to the wheel so that the colonies will be more connected to each other. But this wheel, so Franklin is, so to speak, reinventing a wheel, but the wheel goes nowhere in the 1750s, but his ideas become a model for the Articles of Confederation after independence, after 1776. Now, 13 colonies have decided that together they're going to join hands and wage war, a war of continental liberation against the Crown. So they're in this together, and now they need some sort of mechanism to coordinate their military strategy and their defense expenditures and their foreign policy, their treaties vis-a-vis the rest of the world. They're going to need more of a rim. And some of Franklin's ideas that he had floated in the 1750s come to the fore, actually. And one section of the Articles of Confederation, remember, it's not so well organized as a document. Article 4 of the Articles of Confederation actually has some provisions that become, with a little tweaking, and we'll pay attention to some of those tweaks, but some of these provisions of Article 4 of the Articles of Confederation that builds on Franklin's earlier model will become Article 4 of the U.S. Constitution. So here's one idea, that basically people like Franklin should be able to go from one state to another state. Remember, they're no longer colonies. Now they're states. They should be able to go from Massachusetts to New York to Pennsylvania, as Franklin, as a young man, had gone from Massachusetts to New York to Pennsylvania, and not be treated as aliens, not be treated as outsiders. So one idea is that you're entitled as an American to the if you're as an American citizen, to the privileges and immunities of citizenship in other states. So this idea that there should be interstate privileges and immunities of free ingress and egress. You should be able to go from one state to another, in fact, maybe even relocate and move and become a citizen of another state. But even if you're just a visitor, you should be not discriminated against. You should be treated as an insider rather than as an alien. That's the idea. Interstate privileges and immunities of citizenship. You see this in the EU today, for example. You should be able to get a job in another country in the EU, and you shouldn't have to have a passport to travel from one EU nation to the other. Well, that's the idea of Article 4, that free mobility among the states and to treat citizens of one state as insiders in another state. Well, one important change that Article 4 of the Constitution makes is, under the Articles of Confederation, paupers and vagabonds were accepted from this. So if you're poor, a state could basically exclude you at the border. But Article 4 of the Constitution gets rid of that language. So now, in the future, a penniless Ben Franklin leaving Massachusetts to make his fortune in New York or in Pennsylvania can't be excluded, can't be barred at the gate. So that's, I think, a democratic, egalitarian reform. Another thing is that the Constitution is better worded, its Article 4 on privileges and immunities than the Articles of Confederation were. Articles of Confederation were a little bit confused. The Constitution, for example, is going to make clear that when it comes to naturalization of foreigners. People born abroad who come to the United States, individual states shouldn't have that power. The central government should have that power. So it shouldn't be in the authority of any one state to make someone from Europe, for example, an American. That should be decided by the United States rather than the individual states. But a couple of questions. One, who exactly is a citizen? In particular, what about, because there's not quite a definition, a clear definition of who is a citizen. In order to be president, you have to be a citizen of the United States and a member of the House or the Senate, a citizen of the United States. But what does that mean? And in particular, can black people, free black people, not slaves, free black people be citizens? Well, I think the best reading of the Constitution is, yes, they can be if their state, their home state recognizes their citizenship. Free blacks fought at Bunker Hill and in Massachusetts and voted for the Constitution in Massachusetts and several other states at the founding, and were treated completely equally in several of the states. And Article 4 does not use the word white. It could have used that word. Actually, South Carolina wanted it to use that word, but South Carolina got outvoted on that. In the Articles of Confederation, in implementing parts of the Articles of Confederation, sometimes the word actually white was used in certain contexts, but not in efforts, again, to implement the Articles of Confederation, but not in the Constitution. So I think the best reading of Article 4 is it has no race test. And if it had, actually, the people of Massachusetts would have been unhappy with that. They voted down a proposed state constitution in 1778. Because it had some racial qualifications, and the people of Massachusetts in some places didn't like that. They were offended by race tests. So that word is purposely omitted from the Constitution. But in the 1850s, the Supreme Court, which is going to be populated by justices picked by presidents picked by an electoral college, which leans toward the South because of the 3/5 clause. This pro-Southern Supreme Court, presided over by Roger Taney, who succeeds John Marshall. Taney is Andrew Jackson's man. He's put on the court. He used to be in Jackson's cabinet. He's put on the court by Andrew Jackson. Taney, in a case called Dred Scott in 1857, is going to say several things. But one of the things he's going to say is free blacks can never be citizens. Even if they were born free in Massachusetts and Massachusetts calls them a citizen, even if they vote in Massachusetts, even if their free-born father voted in Massachusetts, even if their free-born grandfather voted up for the Constitution and fought at Bunker's Hill, Taney says, no matter, free blacks, people descended from Africa, can never be citizens of the United States, never be entitled to the privileges and immunities of citizens of the United States. Now, I think that was a mistaken reading, and it's going to precipitate the Civil War. Lincoln is going to have a strong reaction to other elements of Dred Scott, not so much that one, but other aspects of Dred Scott. And so in our next lecture, we're going to talk a lot more about race and slavery and how it plays out throughout Article 4 and is eventually going to help us understand why the early Constitution, this very well-organized Constitution, ultimately fails in the 1860s. So stay tuned. Welcome back. We're in the middle of a discussion of Article 4 in the Constitution, and we left off talking briefly about the famous case of Dred Scott versus Sanford, a case from 1857, in which the United States Supreme Court held, among other things, that free blacks could never be citizens, even if their state called them citizens. And even if they voted in their states and their father voted and their fathers voted in states and their grandfathers, didn't matter, said Tawney, because he said Constitution presupposed that only whites, in effect, could be citizens, or at the very least, people descended from African slaves couldn't be citizens. Now, the Constitution doesn't say that at all. Tawney basically is making some of that stuff up. What arguments did he give? Well, he gave some historical arguments that, of course, the framers of the Constitution did not contemplate blacks as equal citizens, but that's just false. They absolutely did. And actually, in Massachusetts, they made a big deal of the fact that blacks were equal citizens. And they rejected the state constitution, a proposed constitution, in 1778 precisely because it had race tests. Well, here's another thing that he said. Gee, if blacks were citizens, that would mean that they could come from the north down to the south, and they would be entitled to all the privileges and immunities of citizens, and those privileges and immunities would include, for example, freedom of speech, freedom of assembly, the right of freedom of religious worship, the right to have guns and carry them around. In other words, he thought that the privileges and immunities of citizens basically included stuff that today we would call the Bill of Rights. Stay tuned on that one. We're going to talk a lot about the Bill of Rights and how it originally applied only against the federal government and eventually came to be applied against the states thanks to the 14th Amendment that uses the same words that you first see in Article 4, privileges, immunities, citizens. So stay tuned. But the thing to remember about Article 4 is it didn't quite tell you that if you went from one state to another and you were a citizen, that you got to carry with you all the rights of your home state. Not quite. What did it say? It said that the new state, the state that you were traveling into, couldn't treat you as an outsider. They had to treat you as an insider. But treating you as an insider doesn't necessarily mean that you're going to get everything you want. Here's what it does mean. That if a person who's just, say I'm a Connecticut person, I go to New York. If a person who's just like me, who happens to be from New York, can own a piece of property, then I can own that piece of property. If they can open up a business, then I can open up a business. If they can have free speech or religious worship, then I can do that. New York has to treat me when I'm visiting New York basically as a New Yorker for almost all purposes, for purposes of civil rights. There's a limit. They don't have to let me vote in a New York election or serve in a New York legislature or jury or militia. Political rights are excluded from the privileges and immunities that New York has to give me. Civil rights, yes. Political rights like voting, no. But what civil rights do they have to give me? Equal civil rights with their own folks. So, for example, if a woman, let's imagine that a state, a woman goes from Connecticut to New York. Now, does she get to vote in New York? Of course not, because actually no one just visiting New York gets to vote, but also because New York women don't get to vote in the 19th century. If the rule, for example, is that married women in New York don't get to own real property in their own name because they're married, well, then a Connecticut woman who goes to New York wouldn't get to own real property in her own name if she were married because she just has to be treated as a New Yorker. So Tawney was afraid that if blacks went down to the South, they'd have to be able to have a right to have guns, because if they had a right to have guns in Massachusetts and free speech in Massachusetts and religious liberty in Massachusetts or Connecticut, when they went down to South Carolina, that they get all those rights. No. What they would get is the rights of South Carolina free blacks, which might not be very extensive. So they would basically have the right to be treated as South Carolinians and so Article 4 was basically a ban on discriminating against out-of-staters as such, discriminating against someone just because they were from Connecticut rather than New York. Article 4, when it talks about privileges and immunities of citizens, is just a kind of interstate equality idea. There are some other interstate ideas in Article 4, somewhat similar. If a state court renders a judgment between two people in Connecticut, A sues B, A wins, B has to pay up, then New York is supposed to give that state judgment full faith and credit. And especially after Congress implemented that in a statute, and Article 4 provided for congressional implementation, that meant that if A sued B and A won, and B basically doesn't have very many assets in New York, in Connecticut, A sues B in Connecticut, and B loses, but all of B's money and property is in, almost all of it is in New York, A can go over and get New York courts to basically follow that judgment and use B's assets in New York to satisfy that Connecticut judgment. New York is supposed to give Connecticut judgments full faith and credit. Treat a Connecticut judgment the same way, in effect, it would treat a New York judgment, in which it would generally give that New York judgment full effect, full faith, and credit. Okay, so we've begun to talk about race and who counts as a citizen. Unfortunately, the Constitution isn't crystal clear on what it means to be a citizen. And the 14th Amendment is going to solve that problem in its first sentence by saying everyone born in the United States is a citizen, whether you're born black or white, Jew or Gentile, male or female, gay or straight. You were all born equal citizens. And that's going to be an important idea that the 14th Amendment is going to add, because the Constitution talked about citizenship but wasn't completely clear on what it meant. Women, for example, and here's what it didn't mean. It didn't mean in order to be a citizen you didn't have to vote. Women, for example, didn't vote at the founding, but they were treated as citizens under Article 4. They got to sue and be sued in court under diversity jurisdiction, which is a provision of Article 3 that says citizens of one state can sue citizens of another state, and women were always counted for that purpose. So to be a citizen doesn't mean you get to vote. You're born a citizen if you're born in the United States on the day of your birth, but that doesn't mean you're a voter. You get, in effect, civil rights, but not political rights. You have all sorts of rights, but not necessarily rights to vote or to hold office or to serve in a jury or a legislature. Those political rights are treated as different from the general civil rights of citizens. Think about a woman. An unmarried white woman has all sorts of rights in most states, of religious worship, of free speech. She can own property in her own name, but she has all sorts of civil rights, but not political rights, not yet. Stay tuned. We're going to find out how and when women did get political rights later in our lecture series. So we've been talking about race and slavery a little bit. Slavery and race is not one issue. It's 6 or 7 or 8. It's the status of free blacks and whether they can be citizens. We've been talking about that. It's a question of how slaves are going to be counted for the House of Representatives. We talked about that, the 3/5 clause. How slaves are going to be counted for presidential elections. Well, the same 3/5 clause feeds into the Electoral College. It's about runaway slaves. What happens if people from one state where slavery is legal escape and venture into another state? The fugitive slave issue, and we're about to talk about that because Article 4 talks about that. It's slavery. Also, we're going to need to talk about slavery in the territories. That's a different issue, and in fact, that's going to be the issue over which the Union basically breaks in the 1850s and 60s, the issue of slavery in the territories. It's about an international slave trade. And remember, Congress can't prohibit the importation of slaves before 1808, but is allowed to prohibit the importation of slaves after 1808. So slavery, again, isn't one issue, it's a whole series of issues, and it's kind of connected. And my big claim is going to be that the framers failed in a way by not using the 1808 idea more. Okay, we're going to concede all sorts of things to pro-slavery folks today, but after 1808 or 1828 or 1876 or 1878 or whatever, after a certain point, no more concessions, no more slave importations, no more slavery in the West, no more fugitive slave rendition, no more extra credit for extra slaves in the House, no more extra credit for extra slaves in the Electoral College, etc., etc. Maybe at some point, no more slavery after a certain point. Slavery shall end even in the states, because yet another issue is slavery in the states, and does Congress have power to regulate that? And the answer is not quite under the original Constitution. So slavery isn't one issue, it's a series. And let's talk about a couple of the other issues that are front and center in Article 4. One is the Fugitive Slave Clause. So under that clause, if someone runs away as a lawful slave in one state, say South Carolina, runs away, escapes into a free state, say Massachusetts, what does Massachusetts have to do? And the Articles of Confederation didn't have an answer to this. English law basically said, in effect, could be read to say, well, once you make it to free soil, once you make it to England, basically, we're not going to enforce the slavery. Maybe we're not going to declare you completely free, and if somehow you went back to South Carolina, maybe slavery might reattach. But while you're in English soil, we're not going to let you be enchained. Maybe you owe an apprenticeship or something, but no slavery will be allowed on English soil. It won't be hereditary. Maybe apprenticeship or something like that, or indenture, but no slavery because English soil is free soil. So said a famous English case, Somerset's case, and that would have been the rule, I think, in the United States, the background rule of choice of law, of conflicts of the law. What's the general rule? The general rule is, when in Rome, do as the Romans, the law of the place. In Wyoming, you're allowed to drive 80 miles an hour, maybe, but when you come to Connecticut, it's 55. And if you want to drive 80, go back to Wyoming. Slavery might be legal in some places, but not in others. And if a slave escapes, then it's to a free place, then it's the law of freedom. That's what the background rule might have been understood to provide. But Article 4 says, no, the slave state, a free state, first, can't free the fugitive slave, can't declare the person officially free. They have to give, basically, they have to respect the slave state's law on this. Not only can't they officially free the fugitive, they have to actually send the fugitive back to the slave jurisdiction if they're convinced that the person is really a fugitive slave, as opposed to a free black person in the case of mistaken identity, or someone who had been previously freed, previously emancipated in the slave jurisdiction. So they only have to send them back if they really are a fugitive slave. And in that way, it could be seen as a bit of a compromise between slave state interests and free state interests. The slave states basically get their slave back, but the free states get to apply their own procedures for determining whether this person really is an alleged fugitive. And by the way, if you didn't have that provision, there's another provision of Article 4 that says anyone charged with a crime by one state has to be extradited, and who's found in another state has to be extradited back to the charging state. And if you didn't have a fugitive slave clause, maybe the South could have said, okay, fine, we're going to charge this person with a crime. We're going to charge the person with a crime of having stolen the horse that he escaped on, because that was the master's horse. Having stolen the clothes and the shoes that he was wearing, because that was the master's clothes and the master's shoes. Having stolen himself, because he himself is slave property. And under the fugitive from justice provision, the criminal justice provision, the northern state would just have to send them back down south for adjudication as to whether they really committed those crimes. But the fugitive slave clause, I think, fairly read, said, no, actually, the northern states are going to get a little bit more as part of this bargain. They're going to be able to decide for themselves whether the person is truly a fugitive slave or not. At least that's how you could have read the Constitution in pro-freedom ways, anti-slavery ways. The Taney Court is going to read these provisions in very pro-slavery ways. They're going to actually insist that northern states send people, alleged fugitive slaves, sort of back without being able to follow fair procedures. They're going to uphold congressional laws implementing the Fugitive Slave Clause, even though there's no express power in Article 4 for Congress to implement the Fugitive Slave Clause. But Congress passes laws, and the law of 1850 is going to say the alleged fugitive slave, he's only alleged, can't testify in the northern proceeding can't call witnesses, doesn't have a lawyer, and the judge who decides that, the magistrate, will be paid more if he decides the person's a fugitive slave than if he decides the person's free in a case of mistaken identity or something. So it's a dreadful law. The North is really going to rebel against it. It's going to be one of the precipitating factors in the Civil War, the Fugitive Slave Clause, which gets implemented in pro-slavery ways. It's pro-slavery in its bones to some extent, but it gets implemented in even more aggressively pro-slavery ways by Congress and the Taney Court. But the real issue that precipitates the Civil War, the real race and slavery issue, isn't the fugitive slave issue. There are not that many fugitive slaves. It's the issue of slavery in the territories. Before I say, and that's an issue that was involved in the Dred Scott case. In the Dred Scott case, the slave Dred Scott from Missouri is taken by his master to free soil in the North, the Union Territory, and then returns to Missouri. And he says he's been freed because his master took him onto free soil. Now, you might wonder why the Fugitive Slave Clause didn't apply in this situation. Dred Scott didn't run away. He wasn't a fugitive. So his master voluntarily took him onto northern free soil. And so the Fugitive Slave Clause doesn't apply. So that's yet another issue. The issue, we talked about all the issues of slavery. Here's another one. What about someone, a master voluntarily taking a slave from slave soil to free soil? Well, here's what the Constitution says about that. In Article 4, Congress has sweeping power to regulate the federal territories. And Congress, exercising that power in the first Congress, said no slavery in the Northwest Territory, north of the Ohio River. That's federal territory. It's not yet a state, but there won't be slavery allowed there. And everyone who voted for the Constitution understood that that could happen, anticipated that. People like James Wilson actually bragged that that's what would happen. That's what did happen. So there's no rule in the Constitution that Congress has to allow slavery in the territories. Basically says Congress gets to choose. It could have been even more pro-freedom. It could have said no slavery in the territories will be permitted. No slavery after 1808 will be permitted, or after 1828 in the territories. It didn't say that. It said Congress can choose. But in the Dred Scott, and Congress did choose to eliminate slavery from the Northwest Territory in one of the very first statutes Congress ever passed, the Northwest Ordinance Act. I think it's the 7th or 8th statute passed by Congress in 1789. And Congress will later exclude slavery from an area north of a certain line in the Missouri Compromise. But Taney is going to come along in Dred Scott and say, you know what? Those free soil laws are unconstitutional. Congress cannot basically prohibit slavery in the territories. The territories have to be places where Southern slaveholders can take their slaves. Now, this was preposterous. He's just making all that up. And Lincoln thought it was preposterous. Now, Congress doesn't even have the power to exclude slavery from the territories. Presumably, Congress doesn't even have the power to let the territories decide for themselves. Stephen Douglas's popular sovereignty solution. So in one stroke, in 1857, the Supreme Court basically says, Abe Lincoln and the Republican Party's idea of excluding slavery for the territories, that's unconstitutional. In effect, Stephen Douglas's strategy of letting the territories decide for themselves, that's unconstitutional. So-called popular sovereignty, that's unconstitutional. This is going to precipitate a civil war. But blame Taney for that. Don't blame Article 4, because Article 4 actually doesn't say that. It gives Congress sweeping power over the territories, and Congress originally exercises that in very pro-freedom ways. Free soil for the Northwest Territory. The Northwest Territory is worth remembering for yet another reason, because it sets a template for how the West is going to be treated. It says these territories will eventually become states, admitted on equal terms with the 13 original states. So this idea, which is also provided for in Article 4, that Congress is going to have power to admit new states, is one of the radically democratic features of the Constitution. Article 4 doesn't quite require, doesn't have a detailed regulation on how these new states are going to be admitted, but the rest of the Constitution says every state gets 2 senators. So if that's true of the 13 old ones, it's going to be true of the new ones too. And every state's going to be represented in the House of Representatives and part of the Electoral College and so on. So the rest of the Constitution, its deep structure, basically says eventually, when these territories are admitted as states, they're going to be admitted in effect on equal footing. And that's a phrase that appears in the Northwest Ordinance. The new states are going to appear on equal footing. We are not going to be lord over the West as colonizers. They won't be perpetual colonists. We will not treat the West the way Britain treated us. A deep anti-imperialist, anti-colonial vision in Article 4, as implemented by the Northwest Ordinance, that these territories are going to come in on equal terms. And here we see the geography idea. A nation's going to need to expand westward, and that's going to give us a buffer. But the democratic idea as well. They're going to come in ultimately on equal terms. And the slavery issue, the Congress is going to, we punt on that. Congress will have the power to decide. One other feature of Article 4, and then I'll sum up. Article 4 gives Congress the power to guarantee that each of the existing states have a Republican form of government. Now, by that, they don't mean Republican as opposed to Democratic, that it has to have a state legislature as opposed to initiative and referendum. No, they mean Republican as opposed to monarchical and aristocratic. Republican and Democratic are 2 different ways of saying basically the same thing. The party that we call the Democrat Party, Jackson's party, is founded by Jefferson and Madison, and they referred to it originally as the Republican Party or the Republican Democrats. Pretty much the same thing. Democratic, Republican mean pretty much the same thing. Republican is Latin, Democratic is Greek. They basically mean rule by the people. Article 4 says then 2 big things. That the new territories are going to eventually be treated as equal states, a very Republican idea, no kind of colonial hierarchy, and that Congress will have the power to ensure that the existing states never lapse into monarchies and aristocracies. Why? Because if they do, they're going to tyrannize their own people, and this is a federal guarantee, actually, that we won't allow that to happen. They're going to be threats to their neighbors because tyrannical regimes are not only threats to their own people, but to their neighbors. Think Saddam Hussein, think Adolf Hitler. And also, if these states don't have proper Republican governments, then the building blocks of the federal regime are going to be compromised because these states are going to have to elect senators and presidential electors. And if Florida has crummy elections, that's going to affect the Continental Electoral College. So each state is going to have to maintain minimum standards of republicanism. This clause in the Constitution is going to become the most important clause of the entire document after the Civil War. It's going to be the clause by which the North is going to reconstruct the South and rebuild them into Republican governments. It's going to, in effect, treat the South the way it has treated the West, making sure that the West has proper Republican governments before it's admitted into the Union. Well, when the South lapsed because of the Civil War, the North is going to sort of rebuild it and make sure they had proper Republican governments before they were readmitted. So this clause of the Constitution, Republican Government Clause, is going to be called the sleeping giant of the Constitution. It's going to reawaken and be the most important provision after the Civil War. Now, I promised I was just going to say a word or two about this political cartoon. At the end, we see the great themes. We see the idea of geostrategy, join or die. America, these colonies border on each other. They actually have to work together. This is a vision of the colonies sort of working together. So you see the geographic idea and the national security idea very powerfully in this image. Of course, and that's Franklin's image. Remember, of course, the other 2 great themes that we've been talking about, in addition to this national security idea. The slavery idea, Can South Carolina really get along with New England, given that New England is anti-slavery and South Carolina is pro-slavery? That's going to be a big question. And the democratic idea. Will this union hold if it's really divided against itself, if some parts of it are pro-slavery and fundamentally anti-Republican, that don't respect equality and free speech and free press and religious liberty? That's ultimately going to be the crisis of a house divided. We're going to talk a lot about that in later lectures, so stay tuned. Welcome back. We've been walking through the original Constitution in textual order. We've covered the preamble. We've covered Articles 1, 2, and 3, the legislative, executive, and judicial powers of the United States. We've talked about Article 4, which focused on states and territories, on the relationship, the horizontal relationship among the states, and the significance of the territories and the way in which the federal government is going to have important powers over the territories to make those territories eventually Republican states admitted on equal footing with the original 13, rather than acting as a permanent colonizer over the West. And how the federal government will also have the power to make sure that individual states maintain basic standards of Republican government, of democracy, of fair elections, and free speech in order to protect the people of each state from a possibly tyrannical government, a military coup, or something like that, to protect the people of each state against its own government if that government sort of fails to maintain minimum Republican standards. And in so doing, also protect neighboring states, because tyrannical, monarchical, unrepublican regimes are threats not just to their own people, but to their neighbors. That's what history has taught us, going all the way back to Philip of Macedon, Alexander's father, who threatened the surrounding democratic regimes in Greece. And also will protect, by protecting the Republican government of each state, the federal government will be able to protect basically its own foundations, because the federal government sits atop state building blocks. State election law defines, at least in the first instance, federal election law for the House of Representatives. State legislatures are picking senators at the founding. State law is determining the selection of electors for the Electoral College. And if states are screwing up basic electoral functions, that's going to compromise the fundamental foundations of the federal government, and that actually did happen with the Civil War. And again, arguably, in the 20th century, when states were allowed for a while to run shoddy elections and to prevent people from voting who had a right to vote. And once again, federal intervention was required. The second Reconstruction of the 1960s, building on the first Reconstruction of the 1860s. So that's what we've talked about thus far. The preamble, how the Constitution is ordained and established, Articles 1, 2, and 3, legislative, executive, judicial power, Article 4, states and territories. We've now made it to the end of the original Constitution, Articles 5, 6, and 7. And that's what I'm going to be talking about today and in the next lecture. These three concluding articles of the Constitution, all quite short, are united by a theme of basically constitutional supremacy. They explain why and how the Constitution actually takes priority over other kinds of law. In fact, they refer repeatedly, as did the preamble, to the Constitution. Remember, the preamble talks about how this Constitution is to be ordained and established. Articles 5, 6, and 7 provide further reflection on the nature of this Constitution. Let's start with Article 5. It talks about how this Constitution is to be amended. And there are basically, under Article 5, 4 amendment pathways. 2 different ways an amendment can be proposed and 2 different ways an amendment can be ratified. It can be proposed, and this is in fact how all the amendments thus far have been proposed, by Congress. 2/3 of the House 2/3 of the Senate. So a special supermajority vote from Congress suffices to propose an amendment. The president actually plays no role in the process. I think the idea is the amendment process is just a different kind of process than the enactment of ordinary legislation. So 2/3 of the House and 2/3 of the Senate suffice to put an amendment out there to be ratified by the states. And in order to succeed under the express terms of Article 5, 3/4 of the states have to ratify. And they can ratify either by state legislatures, or if Congress so provides, special state conventions can be the ratifying body, specially elected state conventions. But again, the rule is 3/4. So two different ways an amendment can be ratified, either by state legislatures or by state conventions. And all the amendments thus far, except one, the repeal of prohibition, the 21st Amendment, have been ratified by state legislatures. So, but two different ratifying mechanisms, but 3/4 of the states, each state counted the same as any other state, and two different proposing mechanisms. Congress, 2/3 of the House, 2/3 of the Senate. There's another proposing mechanism that's never been used. If enough states ask, Congress is supposed to call a proposing convention, maybe on the model of the Philadelphia Convention, to propose amendments to the Constitution that, again, presumably would go to the states for ratification. So two different pathways of proposing: a convention model that's never been used, and a congressional proposal model which has generated all the 27 textual amendments thus far. And two different ratifying mechanisms: state legislatures, 3/4 of them, all the amendments except the repeal of prohibition, the 21st, and if Congress so provides, it can instead, though, provide for state ratifying conventions, special ratifying conventions to ratify a proposed constitutional amendment. So what to think about Article 5? I think several things. One, arguably, the rules of amendment are the most fundamental, most important element of the Constitution. They specify the rules by which everything else can be changed. They operate on a higher plane, if you will, or maybe, if you want to think of it, a deeper, more fundamental level than everything else in the Constitution. These are the rules by which almost everything else in the document can be modified. And Article 5, I think, did a pretty good job of it, especially when we compare it to its predecessors. The Greek regimes that had democracy, even if they had a democratic constitution, they often didn't have good mechanisms for constitutional amendment. The British Constitution, to the extent that it was claimed to just be inherited from the ancients, had no kind of, it was unwritten and no express provision for amendments. Now, parliamentary sovereignty as a practical matter might mean that anything Parliament wants to do, it can do, but then that raises a different problem. Do you really want to allow your ordinary legislature to modify the rules anytime it wants, to modify the rules for its own election, to, for example, end regular elections or expand its term of office a threefold or what have you? Let's think about the Articles of Confederation. Its biggest flaw was that, as a practical matter, it was unamendable. All 13 states had to combine, and because you could never get all 13 states to agree on anything, Rhode Island would always opt out, or if not Rhode Island, someone else. Basically, the framers at Philadelphia were forced to work outside the Articles of Confederation framework. Because Rhode Island refused even to show up at Philadelphia. So if every state had to be on board, it was just a non-starter. And so here's actually what the framers of the Constitution said to their critics. The critics said, listen, you forgot a Bill of Rights. The House of Representatives is too small. There are not insufficient protections for a jury trial. What about unenumerated rights? We've got lots of objections to this thing. And the framers said, the supporters said, well, maybe you're right. But here's one thing that we got going for this plan. It's fixable. It has within it provisions for its own modification. And the Articles of Confederation, as a practical matter, aren't fixable. So, vote for the Constitution now. Once we get it up and running, we can have amendments and we can fix the thing. And we promise, say, moderate Federalists, that we'll work with you on that. So in some ways, the amendability of the Constitution is one of its biggest selling points. Now, compare the Constitution to the state constitutions, the federal Constitution. Some of them didn't have any provisions for amendments. And presumably, the Constitution can be amended by the same mechanism by which it was ordained and established, but that wasn't so clear, at least textually. Some of the states basically allowed the legislature to amend by ordinary statute. So then, in what sense is the Constitution sort of higher and deeper than ordinary law, fundamental law that limits even the legislature, that stands outside the legislature? Other states provided for special legislative votes. So you needed special legislative majorities, but only the legislature could amend. Well, what happens if the people want a constitutional amendment that would limit the legislature? If the legislature has a monopoly on amendment, it's just never going to propose maybe such things that it doesn't like that might limit its own power. Other states said, well, there can be amendments and they can occur outside the legislature, but only at certain specified dates. Well, what happens if you need to make an important change outside those dates? And indeed, in ratifying the U.S. Constitution, a bunch of states, in effect, were modifying their state constitutions, and they were doing so outside the framework of their amendment provisions, outside the date clauses, for example, of their amendment provision. So none of the states really had some states provided for a special convention mechanism for constitutional amendment outside the legislature, but didn't have enough details on how that convention was going to operate. So judged against the baseline of Greece and the British Constitution and the Articles of Confederation and the 13 state constitutions, the U.S. Constitution's Article 5 is fairly impressive. It has some flaws. It doesn't quite say how that proposing convention, which we've never had, is going to work. And that's a big can of worms. For example, how is it going to be apportioned? On the model of Philadelphia, one state, one vote? Or on the model of the House of Representatives, sort of proportion. Who's going to decide what voting rule, not just apportionment rule, but voting rule that convention adopts? Is it simple majority, 2/3, something in between? How are the delegates to that convention going to be picked? Will Congress lay down the rules? Will the state legislatures lay down the rules? So Article 5 is not a model of precision and clarity, but compared to its predecessors, it's not a bad first cut. Critics have said Article 5 is it sets the bar of amendment too high. But early on, in the founder's own lifetime, Thomas Jefferson's lifetime, John Adams, James Madison, and so on, we get 12 early amendments, actually, 10 amendments that we call the Bill of Rights, and an 11th and 12th early on. So these people who gave us the Constitution were able to amend the thing to their satisfaction. And when I was a young person, I used to say, gee, the Constitution is sort of too hard to amend. Things could be a lot better, and they're stopped because 2/3, 3/4 is very high. Now that I'm a little older, I think, yeah, it could be much better, but you know what? It could be much worse. And here's one interesting thing about Article 5. It set the bar high enough that most of the bad amendment proposals have actually fallen by the wayside. They haven't cleared the bar. Maybe it's screened out a few good amendments, but it's also filtered out a lot of bad ones. Almost every amendment has actually made amends, made the system better. And we're going to see that in later lectures. A Bill of Rights, the Reconstruction Amendments, the Progressive Era Amendments, the amendments from the 1960s. So a lot of amendments that have improved the system, almost none that have made it worse. Maybe prohibition, but that gets repealed soon enough with the 21st Amendment. So the amendment mechanism really did work. It worked enough it was supple enough to add prohibition and then to get rid of it. So I think actually Article 5 is not as bad probably as I thought as a young man, one of the biggest questions about Article 5 is it the only mechanism of constitutional amendment, or could the people of 2121 adopt an entirely new constitution outside Article 5 in the same way that we adopted the Constitution itself outside the Articles of Confederation or something? That's an interesting theoretical question, not a big practical one today, perhaps, but who knows? In your lifetime, maybe that issue will resurface. Now, before we move away from Article 5, one other set of wrinkles about Article 5 I wanted to highlight. It says that it has a clause saying, provided that. So ordinarily, 2/3 of the House, 2/3 of the Senate, and 3/4 of the states can create an amendment. And the president doesn't need to be involved, and the states can act, again, either by ordinary legislative ratification if Congress so provides, or by special convention. And then there's this other mechanism that's never been used, states asking Congress for a special convention that gets summoned. By the way, another question is, could Congress call such a special convention on its own motion? Let's say if a majority of Americans from across the country petitioned for some Philadelphia II convention, could Congress provide for that even if the states didn't ask for it? So we've got Article 5, but it has one other clause that I want to highlight, because remember, arguably this is the most important part of the Constitution, determining how everything else might be modified. Article 5 says, provided that, these are the ordinary rules, provided that, that the rules for importing slaves won't be changed until the 1808 clause won't be changed. So we're not going to, according to Article 5, we don't want an amendment that says you can start prohibiting the importation of slaves in 1800 or 1795 or whatever. Well, that's a moot issue today because we're past 1808 and we've gotten rid of not just the international importation of slaves, the slave trade, the Atlantic slave trade. We've gotten rid of slavery itself. So that provision, and that's the 13th Amendment, and we'll talk about that in great detail in later lectures. So that's kind of a moot point. But the other provision of Article 5 says, no state can be deprived its equal weight in the Senate without its own consent. So you might think, as a practical matter, if we wanted to change the Senate, if we wanted to have a proportional upper house, as well as a proportional by population lower house, if we wanted our Senate, U.S. Senate, to look like state senates, which are proportional. They're not malapportioned. It's not one county, one vote in state upper houses today. If we wanted to change the Senate, you might think, as a practical matter, we'd need every state to sign on, because no state can be deprived under this proviso of its equal weight in the Senate without its own consent. So you might think 2/3 of the House and 2/3 of the Senate and 3/4 of the states wouldn't suffice. I think you'd be wrong about that. Because this proviso that got added on the last day, everyone wanted to go home, or the last week, and it wasn't thought through very carefully. It was not part of the great compromise, which took many weeks at the Philadelphia Convention between a proportional House and states counting equally whether they're populous or not in the Senate. That's the great compromise. That was a big deal in Philadelphia. Lots of discussion of this Article 5 proviso, sort of cementing that compromise into Article 5 itself with special rules, was kind of added on at the end. They didn't think it through very carefully, and so here's the point. Fine. We won't amend the Senate's apportionment by 2/3, 3/4. We can't do that, but here's what we can do. We can take the power from the existing Senate and give it to a new body, call it a new upper house, call it the Schmenit, if you will, and that can have almost all the powers of the existing Senate, and we can create that by a simple constitutional amendment that would go through the ordinary Article 5 rules, 2/3, 2/3, 3/4, because the proviso only kicks in if we're modifying the apportionment rules of the Senate itself, not if we're taking power from the Senate and giving it to another body. Or at least I think that's probably the best reading of the Constitution. Note, though, that small states are still going to have a lot of protection in that system, because even an ordinary amendment has to pass the Senate by 2/3 vote, and in the existing Senate, each state counts equally, whether it's populous or not. Even under the ordinary rules of Article 5, 3/4 of the states are going to have to say yes, and each state is going to count equally in that process, whether it's Wyoming, which not very many people, California, 70 times as large in population. So the small states are protected by the ordinary rules of Article 5 to a very considerable degree. Now, later in the semester, we'll talk about whether it's even imaginable in the future that we might have a different kind of Senate. That takes us to the end of Article 5, and you might ask, okay, well, what's left? We've now talked about how the Constitution is ordained and established in the preamble, legislative, executive, judicial power, Articles 1, 2, and 3. We've talked about federalism, the relationship among the states, and talked about the status of the territories, Article 4. We've talked about the rules of constitutional amendment. What's left? Two things are left, Article 6 and Article 7. That's what we're going to talk about in the next lecture, so stay tuned. Welcome back. Well, we've covered the preamble, how the Constitution was ordained and established, Articles 1, 2, and 3, the legislative, executive, and judicial powers. Article 4, federalism, the relationship among the states horizontally, and the related powers of Congress to sort of monitor states for basic compliance with foundational principles of Republican government, and the related power of Congress to regulate the territories in such a way as to eventually make them into proper Republican states that will be admitted as new states on equal footing with the old. We've talked about Article 5, the provision of the Constitution setting forth how it's to be amended. And you might say, okay, well, what's left? We've kind of covered everything. Not quite. Articles 6 and 7, both of which are quite short, remain to be discussed. Article 6 is going to be an elaboration of the supremacy of the Constitution, its status as supreme law of the land. And Article 7 is going to give us a little more specificity about how this ordainment and establishment process is actually going to work. What do you mean, we, the people of the United States, do ordain and establish this Constitution? You know, who's the people? How do we cash that out concretely? You know, how united are the states going to be coming into this thing? How's all that going to work? So first, Article 6. Article 6 is a provision of the Constitution conventionally referred to just as a shorthand, the supremacy clause of the Constitution. It establishes that the Constitution is the supreme law of the land, notwithstanding anything in any state constitution or state law. It's supreme over federal statutes. It's supreme over federal treaties. It's supreme over all forms of state law, state constitutional law, state statutory law, judge-made law. And, in fact, judges, both of the federal government and of the states, are oath-bound to treat the Constitution as supreme law of the land, as are other officials, state and federal, the president, the Congress, cabinet officers, state executive and legislative officers. So this is the supreme law of the land that every official, really, state and federal, is oath-bound to recognize as such. Now, a few things about that. One, the Articles of Confederation said nothing of the sort. They never described themselves as law, much less supreme law, much less supreme law that state judges had to respect even over state constitutions. And, in fact, the Articles didn't even say that anything the things that Congress did were laws, didn't describe the old Congress as a legislature. Did use the words law and legislature, but only referring to state laws and state legislatures. And so state courts under the Articles of Confederation really treated the Articles as basically no more than a treaty. And the rule of treaties was that they could be superseded by later statutes. And so state courts sometimes basically allowed state statutes to that were passed after the Articles to, in effect, deviate from the Articles. But the Constitution says none of that anymore. The Constitution is supreme law, and it's supreme over all forms of state law, and state judges, among others, are oath-bound to treat it as such. And the point here is not just that the Constitution says this. You know, anyone can just say it. But today in America, everyone respects that. People actually don't go around saying, well, an ordinary statute can repeal the Constitution, or judges can make stuff up openly. Judges can openly proclaim that the real supreme law is what they say rather than what the Constitution says. You might think judges have misconstrued the Constitution, but they all purport to be applying the written Constitution, as do state officials, and so sociologically as well as formally, the Constitution really is the supreme law of our land that people take oaths to and as a general proposition take quite seriously, both ordinary citizens and government officials. Now the question is, why is it the supreme law then? Okay, it says so, professor, and okay, everyone seems to accept that today. It wasn't quite true in the 1860s with the Civil War, but today they seem to accept this. Well, why? Why should it be the supreme law of the land? Why should stuff that happened 200 years ago be more important than a statute adopted tomorrow by the House and the Senate and signed by the President? Isn't that statute today in the here and adopted today in the here and now, why shouldn't that be the supreme law of the land, trumping something that a bunch of old white dead guys agreed to 200 years ago? And I think the answer is that the Constitution is the supreme law of the land because actually in some very real ways it's got a deeper democratic foundation. It's higher because it's deeper. It comes from the people themselves. Remember, at the time of the Constitution, people who, in fact, might not be eligible to vote for state legislatures, might not be eligible to vote for Congress, got to vote on the Constitution itself in a process that involved a whole year of ordinary people talking to each other about how they and their posterity would be governed, the sort that doesn't happen when ordinary laws are being passed, the latest tariff bill or tweak of the antitrust laws or budget or what have you. So the Constitution is the supreme law of the land because it comes from the people. It's higher law because it has a more democratic foundation. And amendments trump ordinary statutes because it was much harder to adopt them. A much broader democratic consensus. That's Article 5. 2/3 of the House have to agree on a constitutional amendment. 2/3 of the Senate. And then 3/4 of the states. So if it's hard to get an amendment adopted, 2/3, 2/3, 3/4, it should be equally hard to repeal that. It should take another 2/3, 2/3, 3/4 to undo what that special 2/3, 2/3, 3/4 have done. So amendments should trump ordinary statutes because an ordinary statute just needs half of the House, half of the Senate, and the President, and the states don't even weigh in. So an ordinary statute doesn't have the same democratic pedigree as the Constitution itself or its amendments. Now, once you understand that basically the Supremacy Clause has kind of a democratic gradient to it, you can see why the Constitution and trumps a statute. So only statutes, congressional statutes passed in pursuance of, consistent with the Constitution, are the supreme law. You can understand why it should trump an ordinary treaty. A treaty shouldn't be able to change the Constitution. 2/3 of the Senate, with the President on their side, shouldn't be able to modify what 2/3 of the House, 2/3 of the Senate, and 3/4 of the states have agreed to. So the Constitution should trump a statute, should trump a treaty, should trump state constitutions, because that's only involving one state rather than we the people of the United States as a whole, should trump a state statute a fortiori. That's a Latin phrase meaning even more strongly. If the U.S. Constitution says it's the supreme law of the land, notwithstanding anything to the contrary in a state constitution, well, it also goes on to say, notwithstanding anything to the contrary in a state statute for the same basic reasons, a fortiori. A state statute is lower than a state constitution. So when some people sometimes ask me, well, didn't the secessionists have a leg to stand on in the 1860s? Where's the Constitution prohibit secession? I say, what part of the Supremacy Clause do you not understand? I have kids, sometimes I look at them and I say, what part of no did you not understand here? So the Supremacy Clause says the Constitution is the supreme law of the land, notwithstanding anything that a state does. So once you're in, and the Supremacy Clause makes that clear. It's going to turn out, Article 7, that you don't have to join the thing. That Article 7 is going to explain that if you don't vote for the Constitution, you're in New York, you're not bound by it in New York. Or if you don't vote for the Constitution, if Rhode Island doesn't say yes, Rhode Island's not going to be bound by it. But once Rhode Island says yes, once you're in, you're in. And we'll talk a little bit more about that when we get to Article 7. One more feature of Article 6 that I wanted to highlight for you is, okay, the Constitution is the highest law because it's most democratic along with its amendments. Then come federal statutes that are in conformity with the Constitution because they're passed by a continental body, not quite as democratically participatory as the amendment process, as the ordainment and establishment process, but next best. Later on, the Supremacy Clause says state constitutions and state statutes are later. But it also talks about federal treaties. And treaties are below the Constitution, and they're above state constitutions because treaties involve all of the United States. But what's the relationship between federal treaties and federal statutes? Now, courts have basically said treaties and statutes are both below the U.S. Constitution and above state constitutions and state law, but they're on the same level. So basically, the courts have said the last in time rule applies. If you've got two statutes and they conflict, which statute do you go with? The more recent one, because they're on the same level. And if they're on the same level, you go with the more recent one. But if something's on a higher level, it trumps even if it's older. The Constitution, even if we're talking about a 14th Amendment adopted 150 years ago, it trumps a statute tomorrow that's inconsistent with it because it's on a higher level. But as between one constitutional amendment and another constitutional amendment, it's the later amendment that governs. So we repeal prohibition. As between two statutes, because they're on the same level, it's the later statute that trumps. As between two treaties, it's the later treaty that prevails. And so the argument courts have adopted is, well, treaties and statutes are pretty much on the same level. So statutes can repeal treaties, and treaties can repeal statutes, whichever is more recent. But I think if you look carefully at the Constitution, it says the Constitution, statutes, and treaties in that order. Statutes are higher than treaties, and they're higher than treaties. They're mentioned first because they're more democratically accountable, because you have the House of Representatives involved. And so, although this is not what courts have said, it closely tracks what courts in general have in fact done, which is understand that there are certain things that actually treaties can't do. Here are some things that you shouldn't be allowed to do by a mere treaty. Shouldn't be allowed to raise an army by a mere treaty. Only the House of Representatives needs to be, I think, involved in that. And that's why the Army lapses every 2 years, and that's tied to elections for the House of Representatives every 2 years. An ordinary treaty shouldn't be allowed to create a new federal crime. Only Congress should be allowed, the House of Representatives, to create a new crime, or to raise an internal tax, or to declare a war. There are certain things structurally that you need the House of Representatives to be involved in, and I think the same is true if you're going to repeal a statute that was adopted with the House of Representatives' participation. You shouldn't be allowed to do that by a mere treaty. A treaty can say, we promise we will repeal some pre-existing statute, but then Congress needs to repeal that statute and the House of Representatives needs to get involved. In technical law talk, certain sorts of treaties cannot be self-executing. They require subsequent congressional legislation. So, for example, when Thomas Jefferson tells Napoleon, we're going to buy Louisiana from you, and the Senate says, yes, we are, great, but who's going to pay for that? You need the House of Representatives to be involved in a bill that spends a dime, or raises an internal tax, or creates a new federal crime, or raises an army, or declares a war. And I think symmetrically, by sort of similar structural logic, the House of Representatives needs to be involved if a federal statute is to be repealed. So treaties should trump state statutes and state constitutions because treaties represent the United States, but treaties aren't really at the same level as statutes. So I say the Constitution, laws, and treaties in that order for democratic reasons. And by the way, that's the order in the Supremacy Clause itself, if you look at it carefully. Okay, so the supreme law of the land, and it's the law of the land, the entirety of the United States, including its territories, including any state. Once a state is in, it's part of the land. If you don't like it, you're always free to leave, but you don't get to take the land with you, the water with you. All Americans basically fought to defend Charleston Harbor in the War of 1812, and so the people in Charleston don't unilaterally ever get to turn those guns around and point them into the bellies of their fellow Americans. All Americans fought for New Orleans in the War of 1812, a kind of Revolutionary War Part 2. Since the entire continent basically helps defend that for good geostrategic and national security reasons, the people in New Orleans shouldn't be allowed just unilaterally to turn those guns the other way. Andy Jackson understood that. He stared down those South Carolinians when he was president. He was born in South Carolina, but he stared them down. He understands the importance of New Orleans. He's the victor of the Battle of New Orleans. And so for very sound geostrategic reasons, the Constitution says this is the supreme law of the land, notwithstanding anything in any state constitution, any state law. A state on its own can't take itself out of the Union. The Supremacy Clause is pretty emphatic about that. So listen up, Rick Perry. And as we talked about in our first lectures, people adopting the Constitution in the preamble